Remarks. Welcome to our monthly webinar series. In these 30-minute webinar sessions, various attorneys from the firm present on a variety of legal topics, everything from novel legal issues facing school districts to reminders on best practice tips. My name is Kaitlin Atlas, and I'm an attorney here at Franczek. The majority of my practice focuses on counseling K-12 school districts through students and special education issues, and particularly through due process issues. So I am thrilled to be with you here today to present on best practices at IEP meetings to avoid due process, so that hopefully none of you ever have to talk to me, even though I am always happy to talk to all of you. I hope some of you are able to join me from outside today because it is a beautiful 70-degree day in November. Who would have thought? Before we dive in, I do want to remind everybody that we have the lovely question answer feature here on Zoom. Please feel free to write in your questions as we go. I will try my best to have joint attention and address the questions as we're going through, but I will also make sure to save a few minutes at the end so we can look at some of those questions. I know some of you were kind enough to submit your questions in advance, and I will try to sprinkle those through as we're talking today as well. I also want to remind everybody that this webinar is recorded, so if you have to jump off for a meeting or for any other reason, know that it will be recorded and posted on our website relatively shortly. And to that end, if you are writing in questions, I would just remind you to keep them at the hypothetical level and not about specific students, so that we're not identifying any students as we're talking today. I also have to give our always disclaimer that this presentation is not legal advice. To the extent you have student-specific situations, please address those. You're welcome to call me. You're welcome to call any of my colleagues here at the firm or your own legal counsel to work through those issues. Without further ado, I would like to start today by talking about some data. So anecdotally in my practice, what I have seen at the start of the 2022-23 school year is a very rapid increase in due process requests and a very rapid increase in mediation requests. The Illinois State Board of Education publishes a report once a year on the number of due process requests and what those due process requests were for. Of course, we don't have the 22-23 report yet because we're still in the midst of the school year. But the 21-22 report was just published, and it found that there were 266 due process complaints filed. I will tell you my best guess, I'm not a betting person, but my best guess is that this number will be higher next year. What I am seeing in my practice is more requests, and I think some of that is due to we are now kind of back at this new normal. The past few school years, I certainly don't need to tell any of you, were unusual. No one wants to say the word COVID anymore, but I think that kind of made for a difference in what we were seeing in due process. Now that we're back at this new normal, what I am seeing is an increase in requests where parents are saying, number one, I'm not seeing the progress I would have expected. My student is now in 4th grade and I'm not seeing them reading where they want it to be. On the flip side, I'm also seeing a lot of school districts saying, we are seeing behaviors that we have never seen before. This is unprecedented, and we are moving towards more restrictive placements for students due to the severity and intensity of their behaviors. So nevertheless, last year we had 266 due process complaints filed. The good news, however, is that only 7 of those were fully adjudicated through a due process hearing. So what that means is still the vast majority of cases settled in a resolution session, mediation, or through settlement agreements or other efforts of the parties. What I will share anecdotally is what I am seeing is before we were generally successful at settling cases at that first mediation session. I am seeing cases draw out for a little bit longer now. People aren't quite ready to settle in that first mediation session as they once were, but we are generally, as you can see in the majority of cases, able to reach that settlement. The Illinois State Board of Education's report also publishes data on what the issues were in those due process cases. So if you haven't had an opportunity to review this report, I recommend you go on the Illinois State Board of Education's website and take a look, because it breaks it down in really great detail. It's very helpful. By and large, for the 21-22 school year, the biggest issue identified in due process complaints was placement determination. So especially now, as I am working with school districts and seeing us really talk about more restrictive placements for students, I anticipate that will be a continued trend over the next year, 2 years, at least. So without further ado, I want to go into what are some best practice tips that we can use in IEP meetings so that you are never in a due process situation. Now, I can't promise if you follow all these tips, you still won't end up in due process, but what I can promise is if you follow these tips, you are doing the best that you can to, number one, avoid due process, and to number two, put your school district in the best situation possible so that if you do have to litigate a due process dispute, you're on as good of legal ground as you can be at that point. So number one tip is make decisions. That sounds pretty easy, right? It's not so easy when you are at the table. What I see a lot is we get at these meetings and there's disagreement with the parents and it's awkward. None of you went into education to make people unhappy or to not work collaboratively with parents. So we reach this point in the meeting, the parents say we disagree. We can't believe that's what you're recommending. Or on the flip side, this is what we want and I don't understand why you won't just give it to us. And it gets awkward. So sometimes I see teams say, you know what, why don't we all just go take some time? Let's all go reflect and come back to the table. While that sounds really great, what happens is it leaves things open-ended and hanging, and nobody really knows what's next, right? We have this unfinished IEP. What are we doing with the child at this time? Nobody knows. So my recommendation is that we reach conclusions. Yes, sometimes it is uncomfortable, but we just have to kind of get to that point of saying, okay, we are going to agree to disagree, and this is the consensus of the IEP team, which we'll discuss a little bit later. I want to remind everybody that their parents have to consent to evaluations, reevaluations, and initial placement into special education. Regarding all other issues, right? So our annual goals, our service minutes, placement after that initial time we start special education. For those issues, the district has to create and propose an IEP that we believe provides the student access to FAPE, and that is discussed in the IEP meeting. And ultimately, if the parents disagree with what the consensus of the IEP team is, the parents' recourse is to file for due process. So what I recommend when we have those situations is we say, this is the consensus of the IEP team. We understand and will document that you disagree, and we provide a copy of the procedural safeguards. I know that most parents, some of you may be parents yourselves sitting in this session, have 100 copies. I had someone tell me recently, I am going to wallpaper my home with the procedural safeguards. From a legal perspective, you can't give them too often. So what I would like to see is if you're emailing the IEP team home, emailing the IEP home, attach the IEP, attach the procedural safeguards. If you're mailing it home, throw a copy of the procedural safeguards in there. That way we avoid any claim that the parent didn't know what their recourse was. As far as the consensus, I want to make sure everybody understands there is no vote, right? We're not going to go around the table and say, do you think that Johnny requires placement in a therapeutic day school? Okay, Mrs. Smith, Mrs. Jones, Mrs. So-and-so, we're not going to go around and take a vote. It's a consensus. And that consensus is ultimately determined by the person who's chairing the meeting. So what I recommend when we have this disagreement is after we have the discussion, the chair of the IEP team meeting says, okay, the consensus of the IEP team is, in my example, the consensus of the IEP team is we are going to change Johnny's placement to a therapeutic day school. I don't want to, again, this is repetitive, but I don't want to avoid reaching that decision just because we know the parent will disagree. The parent has recourse if they disagree. The last bullet point here is perhaps the most important thing I will say today. So I always say, if you're not listening to me for 29 minutes of this, but you listen for 1 minute, listen now. And that is the importance of the additional notes. I think the additional notes section is the most important section of your IEP. That is where you have an opportunity to explain what happened and what each party's position was and where we landed, right? So I will give you a sneak peek into the life of Kaitlin Atlas and what I do, right? I get a call and it says, hey, we have this new due process complaint. What do we do? My first question is going to be, send me the due process complaint and send me the student's last IEP, because I want to see, where is the dispute? What are we fighting about? I get the IEP via email, I print it out, and I scroll to the back. It used to always be to the back, to the additional notes. Now some of you have them in the front, which is always very confusing to me. But I find the additional notes in that packet, and I see what happened. So sometimes I'll get that packet and it'll say, IEP meeting was held. Well, that doesn't really give me much context into what happened at the IEP meeting, right? What I would like to see in that section is a discussion of what happened. So say we're using my example, we have a placement case. I'd like to see the school team proposed placement at a therapeutic day school for Johnny because of X, Y, and Z, right? Data-driven decision. These are the things that we looked at. The parents disagreed because of A, B, and C. The consensus of the IEP team was Johnny will be placed in a therapeutic day school. The parents disagreed. So then I can hone right in on, this is where the dispute is. I understand what happened. I understand what each party's position was. For our next best practice tip, invite the right people. And this is my attempt at being cute on a slide, right? We have our beautiful wedding invitation here, and then we have our less beautiful notification of conference. If it were my choice, we would all be getting these beautiful wedding invitation style invites to an IEP meeting. I love stationery. For those of you who know me, you probably already know that. Alas, we are stuck with this less pretty notification of conference, but it is important that we are inviting the right people. So who needs to be there? Who needs to be invited? We need to have the parents. In most cases, we should at least invite the student. Now, those of you who have worked with me know I am a very big proponent of having students at their IEP meeting. I, of course, understand, are we going to have a 5-year-old kindergartner at a full re-eval meeting for 2 hours? Probably not, but our high school students should be able to participate in their meetings. We're going to have a general education teacher, special education teacher, LEA representative, someone who is qualified to interpret evaluation results if we're talking about evaluations, related service personnel for the related services the student is receiving or may need to receive, and any other individuals with knowledge or expertise regarding the student. So that's kind of our legal requirement. But then you ask me, well, who should actually be there? I recommend that it be people who actually know the student, right? So we have the requirement to have a general education teacher. What I've seen sometimes in IEP meetings is we are so inundated as schools right now with so many issues that we get to the IEP meeting and someone's like, oh my God, we need a general ed teacher. Someone go to the teacher's lounge and pull someone. I would much rather see some advanced planning so we have the right general education teacher there who knows the student. The vast majority of our students are spending the majority of their time in the general education setting. So we really need a gen ed rep who can speak to what the student looks like in the gen ed setting, how they're doing, and what is appropriate in the general ed setting. I also find pre-planning works in your favor when we know a specific issue. So we know, for example, this student is really, really struggling in math. We really have to talk about math goals and math accommodations, but they're doing fantastic in their ELA class. Well, in that meeting, sure, the ELA teacher and the math teacher are both gen ed teachers, but maybe it makes more sense to have the math teacher there because that's really about the meat that we're going to be talking about. And the ELA teacher may not know exactly what would be an appropriate accommodation in math. I also like to pause for a second on the any other individuals with knowledge or expertise regarding the student. That can be a really helpful one to you, right? So for example, we may have a student who is in and out of the dean's office all the time, every day. Maybe it's helpful to have the dean at that meeting to really talk about the student's behaviors and what interventions would be appropriate. I'll frame it with a more positive example. I'm seeing, especially at the high school level, more and more mentorship programs. So we have a teacher who is assigned as a student's mentor. They're not actually that student's teacher in any class, so they wouldn't really be informing the, the general ed role. But maybe we invite that person as an addition because they really know the student well. I think that's great. Next best practice tip. And again, this one sounds really easy, but it can be hard in practice, and that is to be truthful. Parents have a right to meaningfully participate in the IEP process. And in order to do that, they need to know the truth. We need to be candid and we need to use data. So like I said, that sounds really easy, right? Of course, we're going to tell the truth. However, sometimes it's really hard to talk to a parent about where their kid is struggling. And sometimes it feels really bad to sit in a meeting and say, the kid struggles with this, and then they struggle with this, and then they struggle with this. It feels exhaustive. But it's really important that the parent understand. What I have sometimes seen in meetings is we focus a lot on strengths, and I am very, very supportive of that. We should be pointing out strengths. Every student has strengths, and we need to highlight those. However, sometimes we spend so much time talking about the strengths, and then because the challenges are hard and awkward to talk about, we say, oh, and then they have some challenges. And then we jump to, we think your kid needs a therapeutic day school placement. Well, that feels a little bit like a 180, right? When we're saying your kid has all these strengths, they're doing wonderfully. Yeah, they have some challenges, and we think they need another more restrictive placement, right? So we really need to delve into the conversation of challenges. I strongly recommend when we are talking about those challenges, we have data to support it, right? So rather than saying your student has just out of control behaviors, right? Well, that's a very subjective measure. What are out of control behaviors? How often is the student exhibiting them? How long are they taking? Are they taking the student out of their learning setting and academic learning? Making sure we have the data to support that conversation. I touched on this earlier, but the next best practice tip is to pre-meet, but don't predetermine. So you will sometimes hear, oh, you can't pre-meet. You can pre-meet. Pre-meeting is allowed and encouraged. This helps the school team prepare for the meeting, right? You don't want to come in and have any surprises. And I think it's really helpful now that we have our draft IEP requirement that the school-based team come together, make sure they see everybody else's draft goals, draft accommodations, collaborate on some of those draft goals so that we are ready when we go in and we go live in the IEP meeting, right? On the flip side of that, predetermination is not allowed. So when we pre-meet and we prepare our draft IEP, we need to remember that it is not set in stone and we need to go into the IEP meeting with an open mind. So it should never be, well, we're here to recommend X goal. And the parent says, well, what do you think about tweaking it a little bit like this? And we say, nope, we wrote the goal. This is what it is, right? We're always staying open-minded. It doesn't mean you can't land on the goal that you initially drafted, but that we're having those conversations and we're open-minded to change. And everything we walk in with is just a draft, just an idea, just to get the ball rolling. The next best practice tip, and I found another little cute image here, is to ensure meaningful parent participation. So like this man who is carrying his child overlooking a beautiful river, we want to make sure parents have that opportunity at the IEP meeting. Oops. So number one, parent attendance is crucial. Now I understand there may be limited times where parents cannot participate in a meeting or don't want to participate in the meeting. But we as a school should be doing everything we can to engage them so that they do participate. So making sure we're finding a mutually agreeable time and date. That doesn't mean we're going to meet at 9 p.m., right? But that we're at least talking to the family. And if the family says, well, I work Wednesdays, but I can meet on a Thursday, that we're accommodating those requests. Also that we are notifying parents via different means. So we're sending the notice of conference home. Maybe we're emailing it based on your district practice. Maybe we're calling home to say, just making sure you got that notice, but really making sure we've given them every opportunity to participate. We also want to make sure the parent is understanding the discussion. So number one, remember that you have an obligation to provide a qualified interpreter if the parent does not speak English as their first language. But number two, also remember that we in the education field kind of have our own lingo, right? So even if the parent's first language is English, they may not understand really what you're talking about and the meaning of it. So I recommend, just like we do with students, that we sometimes break to have a check-in and say, okay, I just want to make sure you're understanding this conversation. Is there anything you need me to explain, right? So that the parent truly understands what is happening and they're following along and able to participate in the meeting. This is not on the slide, but I do want to remind everybody of our draft documentation requirement to provide draft IEP documents and draft evaluation documents in advance of the meeting. That helps ensure meaningful parent participation because they have an opportunity to review it prior to the meeting. I know when those laws first passed, people panicked of it's going to be one more thing to do. In practice, what I have seen is it's actually making IEP meetings run a lot smoother. And I think parents come into the IEP meetings generally feeling more comfortable because before you might walk into an IEP meeting, hand a parent a 60-page packet and say, okay, this is the evaluation. Got any questions? Right? Now the parent has an opportunity to read it and process it before we walk in the door. We also want to give meaningful, individualized answers. So parents have a right to ask questions, and we want to make sure we're actually answering those questions with meaningful data. On the flip side of that, we also don't want to agree to unreasonable demands. So we want to make sure, I always use kind of this hyperbolic example, right? We have to discuss and respond to the parent's requests, right? So my example is, the parent may request that you take their kid to school in a rocket ship every day, right? Well, we all kind of know that probably that's not going to be practical. But rather than just saying, no, absolutely not, we're not doing it, we don't do that here, right? We don't have rocket ships to transport you to school. Rather than jumping to the no, talk about, well, why do you think your child needs a individualized rocket ship to take them to school? Okay, we understand that. Are there any other things we could do, like maybe a cab to take your kid to school that will work just as well? And having that discussion rather than either one, jumping to the no, or what I've seen is sometimes we're at the end of the meeting and a parent requests something and we just say, we throw our hands up, we say, fine, okay, you want a rocket ship? You got a rocket ship, we just want to get out of the room. Don't agree to those unreasonable demands, because then you may be sending that rocket ship for the next 12 years, right? So we need to make sure we're being careful about that. And my final point, which I touched on earlier, is to document discussions. I really want to make sure we pause here momentarily and talk about how important those additional notes are. Those are your best evidence of what actually happened at the meeting. So for each issue, I want to make sure we have information on the options we considered, what decision was ultimately reached, or what the consensus of the IEP team was, the reason for that decision, and whether there was any disagreement with the decision, and if so, what was that disagreement? What were the reasons for it? And was there any resolution to it? There may not have been. It may just be the parents disagreed. But if it was the parents disagreed, but agreed that we could do this instead, right? Making sure we have all of that in our additional notes. I actually saved 5 minutes for questions, which is remarkable because sometimes I just talk and talk and talk. I want to address some of the questions that came in before this session, and I won't identify the askers just to protect their identity. But one of the questions was about assistive technology. That is a very important part of the IEP, and it's become even more important over the course of my career as we've seen a proliferation in assistive technology that is so helpful for a student. I want to make sure in our meetings we're really diving into, does the student need assistive technology? Should we do an assistive technology evaluation to determine whether there is some assistive technology that could help the student and what that assistive technology is, and then how the student is using it? One thing that's very important is there is so much assistive technology, and I'm sure even as I'm talking here today, even more and more is coming out. Oops. I guess I stopped screen sharing, but there's nothing else on the slide, so that's okay. There's so much assistive technology and more comes out every day, making sure that we are also providing training on that assistive technology. It's really not useful if the student doesn't know how to use it. And I also strongly encourage, though it's not always required, a parent component to that training, especially if it is something like an assistive communication device, so that the parent is able to engage in it and we're seeing continuity between home and school. There was another, I don't want to ignore the person who asked it, but there was another more complicated question on student residency that I do recommend that individual, you're welcome to reach out to me after this session or to reach out to your legal counsel, because I think it's a little more nuanced than we probably have time or the ability to address in a webinar, but I do appreciate the question. It is 12:26, so we have 4 more minutes. I also have a little bit of time after this, so please feel free. I have the question and answer panel open. I just saw one come in. So the first one is, how should districts be addressing the parent training new section, and what would the related services look like? So that's a very good question. So this relates to the IEP forms that changed, was maybe between 6 months and a year ago. Time's all a blur with COVID. There is now a requirement that we consider whether parent training is necessary. So that's in the Model ISB IEP form and should be in all of your IEP forms. I think the answer to that question really depends on the student's needs. There may be times where no parent training is necessary. There may be times where the district's general parent training protocols are appropriate for the student. So we do, special ed parent nights once a month where we document that. Or there may be times where there is more individualized training for parents based on that student's needs. So an example I can give, and this is certainly not appropriate in every case, it's very individualized, but I have seen schools say individualized parent coaching. And some of your special ed co-ops have parent coaches. There are also private parent coaches that your school can contract with. I have seen that be helpful specifically in a case that I can think of off the top of my head where school anxiety was a real issue. So that parent coach helped both the school team and the parent create a plan so that in the mornings, there was a plan in place when the student said, I don't want to go to school, I'm anxious about it, I'm not going, to help the parent get the student kind of out the door, and then to help the school team receive the student and get them into their learning day. So that would just be an example, but there is some flexibility certainly on what those services would look like based on the student's individualized needs. The next question is, what advice do you give to schools for how much weight to give any one evaluation or data point when formulating an IEP? For example, how much weight would a doctor's note receive versus a non-doctor letter? So that again, it's really up to the IEP team and based on the student's needs. I am not at all trying to dodge the question when I say that, but I think it is really, it's really dependent. And it'll probably depend on who that non-doctor is, what they do with the student, how often they see the student. Same for the doctor. Has the doctor seen the student once in the last year for strep throat and now they're making a recommendation about, intensive services? Or is the doctor perhaps the student psychiatrist who they see every week and who is managing their medication? Also, as a reminder on that note, we have an obligation to consider private reports and private evaluations, which means we need to meet and talk about them. But it doesn't necessarily mean we need to just adopt all of those recommendations. Do we need to send draft goals and present levels to parents for an initial eval? So the answer is, prior to developing the initial IEP, you would need to send draft goals and draft present levels. What a lot of districts like to do is pair that initial eval meeting, if the student's eligible, with that initial IEP meeting. That's where it gets a little bit tricky. And different districts have different practices for this. So I would say make sure you check and are complying with your district practice. As I see it, there are a couple of things you can do. One is you could send the draft document home and say, this is just a draft if the student is found eligible. The other option is to separate the meeting into two. So have the initial evaluation meeting. If the student isn't found eligible, schedule that next meeting, the IEP meeting, and provide the draft in advance of that meeting. Or the third option is to ask the parents if they want to move forward with developing the IEP in that first meeting and get them to waive their 3-day draft requirement. There is some risk there because the statute requires 3-day draft. So we're supposed to provide it in advance. That said, if the parents move forward and we document their disagreement or their agreement to move forward, then it may be okay, but that's one that I recommend checking with your legal counsel to make sure they are comfortable as well. And finally, we have, does the notification of conference page have to be signed by parent at the end of every IEP meeting if placement doesn't change or not initial meeting? So the document needs to be signed for the parent to waive 10 days of implementation at every meeting. They have a choice whether or not to sign that. So if they sign it, then you can start implementing that new IEP right away. If they don't sign it, we have the 10-day waiting period. The only time the parent needs to formally consent is for that initial evaluation, reevaluation, or the initial placement into special education. So that first IEP meeting ever. And then I will do one more question, but please know I am available after if you want to reach out. We have a group of parents who attend private ABA therapy. The ABA therapists are recommending partial days week to the parents so they can have time for their ABA therapy. Do we change the IEP if we didn't recommend the shortened day or just excuse the missing time from school on the attendance side? This is a really tricky issue, and this is something that I'm seeing coming up more and more. I want to make clear there are different ways to document it in the IEP, and I want to make sure you consult with your legal counsel so they are comfortable with how it's documented in the event you end up in due process. That said, I want to make sure you are documenting that it is not the school team's recommendation for the student to be on a partial day, right? We think the student needs to be here from our full instructional day, and the goals we are drafting and the services we are proposing are for the full instructional day. From there, then that's when I recommend you work with your legal counsel to determine whether you want to, how you want to document it in the IEP, whether it's in the additional notes, whether you remove goals, how you excuse the absences. That's something that you should address individually. Thank you everybody for joining us today. I really appreciate seeing so many of you here. I hope you all get a chance to go outside on this beautiful afternoon. And as I said, I had my email address up there, but if you didn't catch it because I accidentally put the slide away, it is ka@Franczek, FRANCZEK.com. Please feel free to reach out anytime, and I would be happy to work with you and deal with some of your student-specific issues. Have a great rest of your day, everybody.